Morning, everyone. Welcome back. So happy to have you here. It is my pleasure to introduce our first instructor, Patrick Virgadamo. Patrick is a CFE, a senior attorney for the Office of the Louisiana Legislative Auditor. In his capacity as senior attorney, Patrick has researched and written opinions on numerous and various questions facing the auditor's office, state and local officials, and public entities in general, which arise every day. Patrick is certified as a state agency ethics liaison and certified ethics trainer with the Louisiana Board of Ethics, and he's also a certified fraud examiner. Patrick has worked extensively with the Louisiana Legislative Auditor's Human Resource Section, where he's assisted the General Counsel in addressing human resource related questions and in drafting and implementing numerous internal policies. So before I get started welcoming Patrick, I just wanted to make a comment about how you can join the webinar from only one device. So your registration, you have one registration and it can only be accessed by one device. And what does that mean? So if you register as Lizzie Schexnayder, I can only attend from my computer, or I can only attend from my phone or my iPad or whatever device you wish to use. What you won't be allowed to do is to register, access it on your laptop, and then again on your phone or your iPad or whatever other device you wish to use. So only one device. If you decide to switch devices, you'd have to log off and then log back on to another device. But if you try to do two at once, it might interfere with your connection. So I just wanted to clarify that. So if you're in a group, let's say at your office with 5 people, and you guys all want to register, you have to register individually and attend from your own independent device. So I just wanted to clarify that. Of course, if you have any questions, feel free to put it in the question and answer chat, and I will get back with you about that. I just don't want anything to interfere with your connection. So without further ado, I would like to welcome Patrick Virgadamo.
Good morning, everyone, and thanks, Lizzie. This morning, I'm going to talk with you guys about open meetings law and the public records law. Those are two laws that I think a lot of times people have trouble with, but if you take a moment and take a breath and look at them, they're actually not that hard if you understand the concept behind them. So when looking at the open meetings and public records law, you have to understand why we have those laws. Article 12, Section 3 of the Louisiana Constitution provides that no person shall be denied the right to observe the deliberations of public bodies and examine public documents, except in cases established by law. What this means is we give the people in Louisiana are given a constitutional right to observe and watch how public bodies carry out their business and to look at public documents, except in cases where the legislature by law has said there's a reason you can't. And we'll talk about some of those as we go through this. The biggest thing to understand is this constitutional article is the foundation for both the open meetings law and public records law, which we often call the sunshine laws. And the reason we call it the sunshine laws is former U.S. Associate Justice Brandeis once stated in a case that sunshine is the best disinfectant. The idea that all the horrible things that supposedly happen in politics and in public government can't really happen if everything's done in the light of day. And so the idea behind this is the public should be able to see these. So, first thing we'll get into is the open meetings law this morning. With the open meetings law, some things we'll kind of talk about through the first half of our time this morning is going to be some definitions that you should kind of make sure you understand, some of the general requirements of the open meetings law, specifically talking about executive sessions, the new virtual meeting exception under 4217.1, some special notice provisions specifically in regards to tax and millage issues, what happens if the violations of the open meetings law, and a few recent attorney general opinions. So the open meetings law can be found in the revised statutes in Title 42, starting at Section 11 at SEC. So basically, and following. The provisions of the open meetings law have to be construed liberally in favor of public observation and participation in deliberations and decision of public policy. What this means is if there's a question, if it's at all gray, whether or not the public should be able to watch this or not, the courts, in looking at the law, will err on the side of the public being able to watch and observe those meetings. So one of the things, and when we talk about the exceptions, these exceptions, because they're an exception to a constitutional right to observe, and that it's going to be liberally construed in favor of people being able to watch, it's in essence, you need to make sure that you meet all of the requirements of the exception. If you only meet part of it, more than likely the exception will not apply to your situation. But we'll talk a little more specifically when we get to the exceptions. One thing the law does require is that a copy of the open meetings law, the statutes specifically, are required to be posted by public bodies. That's why if you ever go into an area that's used by a lot of like a parish government, wherever they have their meetings, there's usually a copy of the open meetings law posted somewhere, like on a wall or on a pillar. This also can be essentially resolved by, if you have a website, providing a link to those statutes on your website. It just requires, it doesn't say where it has to be posted, just generally says you have to post it. And the idea is, this is basically, if anyone's familiar with like your employment law things where you have that board in your break room and things of that sort, it's the same thing, but for the public, saying, we want you to understand what your rights are for open meetings. So some definitions we'll talk about. Some big ones that I think you really need to understand if you're going to understand the concept of the open meetings law is, what is a meeting, what is a public body, and what is a quorum. So a meeting, simply put, is basically a gathering where either you deliberate or act on a matter in which the public body has supervision, control, jurisdiction, or advisory power. So you're acting or taking action on things. Or, and this is the one that kind of catches people sometimes, or it's a gathering by them to receive information regarding a matter over which you have jurisdiction, supervision, control, or advisory power. The idea is that if someone's coming giving you a presentation to, say, the police jury, that presentation, if it's on the things that the police jury has control over, has to be held as an open meeting if you have a quorum of the gathering. Now, it's important to understand, a gathering does not include chance meetings or social gatherings at which no vote or action is taken, such as formal or informal polling of members. But you have to think of that also in light of if you're getting information. What this means is, let's say you have the local festival, which I think we're all hopeful we can get back to the normal of having all the festivals Louisiana is known for. You happen to all the people, all the Board of Aldermen happen to be at the local fair. At that festival, just because they're all present doesn't mean it's a gathering for the open meetings law. As long as you don't talk about things that are business, which please don't be that person, enjoy the festival. As long as it's just an informal gathering, social events, or another example would be if you're attending in person, say a conference, where it's not a conference specific to you, but just in general knowledge, that's not going to be a meeting for the purpose of the open meetings law, because you're not gathering to get information about stuff that's specific to you or take action. Now, the way you can violate that is if you're at a conference and everyone decides to go off in a breakout session, just the Board of Aldermen, and you have all of them sitting there and they start talking about business, that can be a problem. Now, public body, this is one that I think you have to understand who is the responsible for the open meetings. It's going to be essentially your legislative group of your government, the municipal governing authority. So the Board of Aldermen, your city council, parish governing authorities, your police jury or parish council, your school board, your levy boards and port commissioners, boards of publicly operated utilities, planning, zoning, and airport commissions, and any other state, parish, municipal, or special district boards, commissions, authorities that have policymaking, advisory, and administrative functions. The key you'll note in those is this isn't the executive side. So it isn't like your department heads and the mayor who may have executive meetings. Those are not open meetings and not meetings for the purpose of the open meetings, because they're not the public body. The public body is the entity, the board, the things that have to get together in order to carry out stuff. Same thing for like an independently elected official. For that official, they're not a public body. Now, in the cases of those that have a district, like an assessment district or a law enforcement district, the districts are going to be considered a public body. So those functions are separate. The other thing to understand about this is that any committee or subcommittee of the above are going to be also included in the public body. So if you have a situation where they formally create a committee or subcommittee, that subcommittee is also going to be subject to all the rules that we're going to cover, whether it's the notices, the agendas, all of those things. Now, you'll note in red below this, the AG has made it clear that nominating committees for appointments to public entities are going to be generally considered a public body. There are some special rules for like private advisory committees where it's private citizens who aren't paid, and we'll talk about that a little bit. But essentially, anything that where they're taking action or advising or receiving information, those are going to usually be that public body. Now, quorum, a quorum, quite simply, is a simple majority of the total membership of the public body. Sometimes people incorrectly identify it as 50% plus one, but the simplest way to think about this is if you're a village and you have 3 members, 2 members are going to be a quorum for you. If you have a 5-member board, it's going to be 3. And for a 7-member board, 4, and a 9-member city council, it's going to be 5. Now, that's the general rule for this. You could have specific statutory definitions of quorum for a public body, and it can be higher or lower than the default definition. For example, you may have a large regional commission whose idea is basically to get different entities all in the same room to talk about things. In some cases, they may be establishing a quorum that's much less just because the sheer size of them and the fact that they're not necessarily taking decisions that would need a majority. So they're more it's because the advice, receiving information, the legislature may in providing for that commission, provide for a lower number. You also could get situations like in higher education, you have sometimes where because there's a combination of faculty, students, administration, and outside people, you may have a combination of things defining quorum. For example, some student technology committees for the technology fee in higher education, they have provisions that it's a double quorum. There's an overall quorum, and then there's a quorum that requires a certain number of students be present for it to be a quorum. You have to really look at your language to see if there's something that changes from the normal definition. One thing to really understand is that vacant positions still count towards your quorum. So if you have a 5-member, you have a town and it has a 5-member board of aldermen. If you have 2 vacancies, you still have to have all 3 of the remaining ones show up because it's still going to be 3 out of 5 for quorum. Those vacant positions will still count, which is why it's important if you get vacancies that you timely fill them, or if you don't do it within the time period in law, have the governor do it for you so that you can have that quorum to continue conducting business. Now, public bodies should be aware that violations can occur when discussions happen through walking quorums. And what walking quorums, simply put, is that the traditional method was council member A goes in and visits with council member B. They talk about something they want to do, but they're not quite sure if they want to do it. Then after visiting with council member B, council member A goes to council member C, council member D, and so forth, so that at one point there was an actual quorum, but constructively they've essentially created a quorum by discussing amongst the majority of the members outside of the open meeting. The modern example of that would be emails, text. It's one thing in the AG, and we'll talk about when we go through some recent AG opinions, it's one thing for you to comment to say one member and say, hey, look, I know you've had questions about this, or have I resolved your issues? As long as it's between those 2, and it's not, say, a village where that's a majority of a quorum of the board, the AG said that can be okay. Where it becomes a problem is where it goes beyond that, and you start talking to the other members so that constructively on that email chain or text messages, you constructively talk to a quorum of the body. And the reason the AG says this is a problem, let's say you go and you're trying to straw poll, which you're not supposed to do. And so you're thinking about putting something up on the agenda. But because of those discussions you've had with a majority of the people, you realize there's not support, so it never gets put on the agenda. The problem is the public never gets to see that discussion. They never get to hear the reasons why for or against something. So that's why those discussions need to happen. So we're going to have our first verification code this morning, verification code number 27, which is going to be 9080. And again, that's verification code number 27, 9080. So with walking quorums with technology, while it's easier to communicate, it's also easier to violate the open meetings law if you're not careful. Now we're going to go through some of the general requirements about meetings, as well as executive sessions, the specific virtual meeting exceptions, and special provisions. So the biggest thing to understand with the open meetings law, kind of like the major commandment, so to say, for open meetings law, is that meetings of the public body have to be open to the public unless the law specifically provides an exception. An example of those would be executive sessions, which are provided for under 42:16, 17, and 18. However, note, with the open meetings law, those exceptions can be found elsewhere in the law. For example, hospital service districts, those under the Enhanced Ability to Compete Act have certain provisions which allow them to do certain things in executive session regarding strategic planning, strategy, and things of those sorts, so that they can not have to air out things that would be necessarily strategic for them in competing against a private hospital. So you have to go look at their law to see that exception. It's not just provided in the open meetings law. Voting, the biggest thing is, except for, as we'll talk about, the exception that was now recently created for virtual meetings, the member of the public body has to be physically present and basically viva voce. And you'll note that we have a typo here. Apparently it auto-corrected to voice, but that's essentially what that means. You have to orally give your vote. The AG has said for things that require a certain, like adoption of an ordinance, you can't just have a showing of hands. You need to know that enough people were there and a majority there voted yes for something. That means either you orally have someone say yay, nay, or in modern society, you can have an electronic voting machine that displays the vote and who cast that vote. And that's important. Anyone who's ever done, say, taxes, where you have that pro se and you're trying to certify things to either our office, to the Secretary of State, you're going to need to show who voted yes, who voted no, and who was absent. So you'll need that recording of that. You cannot use proxy voting unless the law specifically authorizes it. The example that you usually see for that, it'll say so-and-so or their designee. And that means the law has said they don't necessarily have to show up. They can send a designee for that meeting. Secret balloting, straw polling, and other means of circumventing public votes are strictly prohibited. Again, the purpose of this is so that the public can observe deliberations. If you do things outside the public view to avoid that, it's wrong. All votes shall be recorded in the minutes journal or other official written minutes of the body. The idea is that you want to make sure, and we'll talk a little more about minutes specifically, that you're keeping those things so that there's no question that you followed what you were supposed to do for adoption of stuff, but also for historical purposes, you need to go back and see things that maybe someone said, please put this in the minutes. Public commenting has to be afforded prior to action being taken on a vote. So before you vote, you have to allow public commenting. What this means, and we get a question a lot, if we have a meeting and we have public commenting at the end of the meeting, is that okay? No, you have to allow commenting before people take votes. We'll talk about, there's a difference for public commenting for school boards, but in general, you can have a public commenting period at the beginning of your meeting for things that are on the agenda. Now, if you go in and we'll talk about how you can amend your agenda to add stuff, if you do that and then you add something to your agenda, please make sure you go back and allow public commenting before you take up that new item. Some entities will do a general one, but they may still ask, are there any comments on, say, a big agenda item before they actually take the vote? That's important, that you want to make sure the public have a right, because it can be a violation, and if someone challenges it, make it null and void. Now notice, this is probably one of the biggest things, because you can't have an open meeting for the public to participate if they don't know the meeting's going to occur. There are a couple of different types of notices you need to be aware of. First and foremost, if you have regularly scheduled meetings that are established by law, resolution, or an ordinance where it says we're going to have every third Wednesday of the month is going to be our regular monthly meeting. If you have those established at the beginning of the calendar year, you need to publish that notice in your journal and let people know, the public know, when those regular meetings are initially scheduled for. So you're thinking out, okay, this Wednesday in this month is going to be a holiday for whatever reason, so we're going to reschedule it for this. That upfront scheduling of all your regular meetings, you do it at the beginning of the year. For the individual meetings, there's also a notice, and this would apply to people who don't necessarily have regular scheduled meetings. Within no later than 24 hours, exclusive of weekend and legal holidays, before a regular, special, or rescheduled meeting, you're required to give written notice. There are two ways that notice can be done. It can be, in the most common way, it's at the place of the meeting or the official office of the body. You essentially post it outside in the window or at the door. That's the most common way people do it because they can control and make any last minute changes before the 24-hour lock-in period kicks in. The other way is to publish it in your official journal and so, to basically say, okay, here's our official journal. Here's where we're going to have this meeting. You can, it's an or, but you can always do both if you wish. The key thing about the 24 hours is you can't count weekends and legal holidays to make up that 24 hours. So if you're going to have, say, a meeting at 8 a.m. on Monday, you need to make sure that Friday by 8 a.m. you have posted your notice, because you need the rest of Friday and the beginning part of Monday in order to meet that 24 hours. Where it can get tricky for you is if, let's say, Monday is like Labor Day, a recent holiday we've had, the law lets you meet on holidays. You can meet on a holiday. In some cases, an entity may want to do that, or on a Saturday, just because they want to make sure the public can attend. The problem is you need to go even further out on posting your notice, because you can't count any of the day of the meeting if it falls on a holiday or a weekend towards that 24 hours. So you'll need to do it on Thursday, by the end of the day Thursday, in order to count all of Friday for that Monday meeting. And so you kind of want to give yourself, maybe make a sticky note and say, here's how far in advance I need to have my notice posted for this meeting. Just so that if there's any questions or we always have that person who's last minute and wanting to add or change something. You need to have a hard, fast deadline in your head. If you're the clerk of the town and you're the one who posts the notice, you want to make sure you have that drop time to know at this point it's posted, no more changes. Now, there are some changes you can do once you get into the meeting, but we'll talk about those. Now, for notice, you also have to provide written notice of your meeting on your website. If you have a website, a copy of the notice has to also be posted on your website no less than that same 24-hour period. One question we've gotten in the past is, what if we have just a Facebook page for a public entity? The key thing is that won't count. It needs to be a website which you control so that you can post on there. Now, parish boards and commissions, if the police jury and the parish handles you're posting your stuff on their website, you may want to coordinate with them, just so that at the end of the day, the goal is to make sure the public have notice. You can always go above and beyond, but these are the minimum requirements. Now, the last thing is you have to mail a copy of a written notice to the members of the news media who have requested it. We've had this question in the past, and one of the things that we usually try to do is tell people, if you start getting requests, say from your news stations, your radio stations, the newspapers, where they want to know when you have meetings, just create a mail list, so that anytime as part of your process, when you go to post that copy outside, for instance, you also send out that email notice and it goes to everyone who's requested. And so you just keep adding anybody who requests to that list, and you don't have to worry about it. It becomes kind of just an easy function, ordinary function of your process. Now, the notice, and this is important, if you think back for a second, you can understand why it's important. You need to tell people, when are we going to meet, what time we're going to meet, and where we're going to meet. Because if they want to watch it, they need to know when, where, and how, at what time they're going to meet. You also have to include a copy of that agenda that you're posting. That notice should be the date, time, and location of the meeting, and then what you're going to talk about. That notice is usually one thing. Even though it says a copy of the agenda, the notice is usually all of it as one document. If there's going to be an executive session for strategy sessions or negotiations of collective bargaining or litigation, the law specifically requires that some additional information be included. So if it's litigation, you need to have what the docket number, the parties, anything that's pending litigation, something so people understand we're not just saying in general litigation, this is specific litigation is what the exception applies to. And then if it's something to do with prospective litigation, just something that identifies who might that person be. The idea is that people understand you're not just trying to argue, oh, we have potential litigation, so we're just going to go in executive session. No, it's at least gotten to the point where we've gotten a letter from someone saying, if you don't do this, I'm going to sue you. Now, the agenda needs to have descriptive language. Each item needs to be listed separately. The way to think about this is, if you were someone who didn't know better, if you looked at that agenda, would it be something of importance to you to make you want to go to that meeting? It doesn't necessarily have to be completely out there. Let's say you have personnel matters or you're going to talk about. And that, as we talk about, that may involve an executive session. You may just say annual evaluation, performance evaluations may require executive session. That could be your agenda item for that specific item. Now, when you get into the meeting, the officer needs to read aloud a description of those before they take it. That's important so that the public knows, hey, I want to speak on that, so they get up and speak because they know that's what's being taken place. But more importantly, the people who are voting on the board know what they're voting for. So they know this is this agenda item, not something else. And anyone who ever watched a meeting where that wasn't clear knows sometimes it revolves undoing votes, changing votes because you realize you didn't vote on what you thought you were voting for. And so it's important not only for the public, but for the members, they understand what they're voting on and what action is being taken up before you take your actions. No changes, again, to that agenda can occur within the 24 hours. So once you hit that 24 hours exclusive of weekends and holidays before the meeting, that agenda is done. You can't make any physical changes to the agenda. Now, the public body can adopt policies, and a lot of entities will do it either through ordinances or rules where they'll say, here's what you need to do, and here are the deadlines for you to submit things to be on the agenda. So that council member knows, hey, I know I need to by this date and time to get this to the clerk if I want it to be included on the agenda. The public body may amend the agenda and take up additional matters, but they have to do it unanimously. And we're going to stop real quick for your next verification code number 28. It's going to be 5666. And that's verification code 285666. So the key thing to understand with this is it's a unanimous vote of those present. So it takes everyone physically present at the meeting on the board, the members, to vote to add something to an agenda that wasn't put on there before the 24-hour period. You can't reduce this by ordinance, policy, or charter. However, unless you by charter put some kind of requirement for how you withdraw or table items, the AG has said essentially a majority vote, you can just decide not to take it up or to not vote on something. You may want to check to see if you've adopted rules like Robert's rules or some other thing, but even under those, in most cases, majority votes, all that's needed just to not do something. Now, your minutes, you have to keep written minutes of all your meetings. It's often a legal duty prescribed to like a secretary, a clerk, someone of that important position. You have to include in your minutes the date, time, and place of the meeting. That kind of makes sense because if you're looking at a minute, you want to know when and what time and where was this done. Members of the public body, you need to record who was present in absence. This is important because it shows you had a quorum, and it shows when you're trying to determine that enough votes, say for an ordinance, you know who was there and it matches up to who voted yes and no. The substance of matters decided. So you don't necessarily have to, it's not a verbatim transcript. It's just in general, the substance. But if a member specifically says, I want you to put specifically this into the minute, read this into the minutes, that then you would verbatim put whatever that is that was requested. Then you also need to obviously record the votes by the individual members on votes taken. The idea behind this is those minutes, once, if they're certified later by your clerk or whoever does them, they're self-proving that you had a quorum and that the votes were taken to pass something, to properly adopt it, so that if there's questions years from now, especially on tax things, you have a record that shows you did everything you were supposed to do. And then, of course, any other information that the public body requests be included and reflected in the minutes, you'll add those. Now, minutes are a public record and have to be made available within a reasonable time after the meeting, except as otherwise provided by law. If for anyone in our audience that are municipalities, parish governing authorities, or school boards, they are required to publish their journal minutes within their official journal within 20 days of the meeting under 43-143. All other political subdivisions, whether you're a special district, a board, or any other type of political subdivision that isn't a municipality, parish government, or school board, you have to publish your minutes in your official journal under 43-171. So the law, what the open meetings law says is, if you have a website, you also have to publish those minutes online within 10 days from when you published in your official journal. And they have to be maintained online for at least 3 months. Now, one question that's come up before is, I haven't published my minutes yet, but someone had asked for my minutes. Do I have to give them? Yes, the AG has made it clear. You don't wait until the next meeting where something's formally adopted, because any minutes that are in your minutes that need to be corrected should be taken up at your next meeting and will be in those minutes. So within a reasonable time after the meeting, once those minutes are done, you have to give them if you're requested by the public. And we'll talk about that under public records law about responding to those, because they are a public record. However, you don't have to publish on your website until you've actually taken care of your legal duty to publish it in your journal. If for some reason you're a public body who isn't required to publish its minutes in the official journal, then if you have a website, you just need to post the minutes online within a reasonable time of the meeting. To my knowledge, I think the only entity I've ever seen where they didn't require them to publish minutes was like a neighborhood improvement district, where it was essentially the HOA was the board. And for that, they basically just said, have your meetings to do your stuff. But in general, if you're a public entity, a traditional public entity, a political subdivision, you're going to be covered either 43-143 or 43-171. And you're going to be required to post in a journal, which means then 10 days from that publication, you have to have had it up on your, the minutes up on your website, and keep them there for at least 3 months. The idea is that as the oldest one rolls off, the new one's being added. Now, public participation and commenting. This is one where a lot of public entities find themselves getting into trouble recently, especially with the virtual, and we'll talk about where the legislature made it clear you had to make sure people could do this. The public entities have to make sure that a public commenting period is provided before you take action on agenda items. So a public commenting period at the end of the meeting is not going to work for the purposes of the open meetings law. What you may see, and what we commonly see, say for a big entity, you may have a public commenting period at the beginning of the meeting for agenda items. If someone wants just to come speak, they can come speak. You may ask again before you actually vote on the agenda, is there anyone else who would like to speak in case someone come in late or things shifted? And then after everything's taken care of, you may have a separate public commenting period at the end of your meeting, which is for public to bring things to the attention of the body. And some entities, maybe if they meet regularly, may only do it every so often. They'll have that extra commenting period for members of the public to present things to the board for consideration that aren't necessarily on the agenda. Now, obviously, if they bring up something you want to take action, you're going to need to then unanimously vote to add it if it's something you need to take action on at that meeting because it wasn't on your agenda. But that it's different. And as we talked about, school boards are different. School boards specifically are required to have a separate commenting period prior to each individual action on the agenda. So Agenda item 1, before they vote on it, they have to ask for public commenting. Agenda item 2, before they vote on it, ask for public commenting. And that the nature of that is most likely why that was done. Now, all proceedings in a public meeting, with the exceptions of proceedings in an executive session, may be video or tape recorded, filmed, or broadcast live. And the idea is that the public has a right to use a cell phone, whatever they want to do to record an open meeting. However, as a public entity, you have the ability to establish standards for lighting, recording, or where equipment will be placed in the meeting. The idea being, you don't want necessarily someone saying, I'm going to get up front and record my phone, and they're blocking the view of everyone in the meeting. Obviously, you can set up standards to say, if you want to record, you need to record from this area. That area needs to make sure they can still record, but you can do things to kind of keep control and decorum in your meeting. Example, most people will see in a press conference, you'll always see a line of little recorders laying usually up on top of the dais where the person's speaking, as well as numerous microphones for different media. The idea being, we set that up, they stay out of the way so that the person speaking is the focus, but everybody gets the benefit of recording and doing the things they need. Again, and this bears reminding because we get this question a lot, minutes do not need to be verbatim. You're not transcribing or recording and putting everything in it. It's not required, and it's not efficient. But it should provide sufficient description to a reader of what was considered, what the vote's outcomes were, and it identified that legal procedures were complied with on taking up and adopting the matter. Think of it as this: you want to make sure everything in those minutes are there. If you were a person 20 years from now wanting to know, did we do everything right? Because someone's now asking, that you can look in there, see that you met at the date, time, and location. You had a quorum of people present. Everything was done, presenting the question. People had a comment period. All those things, you want to make sure there's no question. But it doesn't need to be line for line what they said. This isn't closed captioning. You're not writing down everything someone says. Now, for non-elected boards or commissions who can levy a tax, those specifically by law have to record. It's not just that people may record it. Those entities specifically are required to record their proceedings, except for executive sessions. However, in 2014, the law was adopted to specifically say these crime prevention and security districts, improvement districts, and those other neighborhood type districts that are created don't have to do this. And it makes sense if you think about it, because then they would have all these little HOAs or these little groups of homeowners having to go find a way to record all their stuff and save it. And so the idea was the members kind of make up who is the people for this. So we're not going to put that on them. Now, executive sessions. This is important because executive sessions are one of those, except as provided by law, scenarios where the public doesn't have a right to observe. You can only hold a closed executive session if it's authorized under 4217 or somewhere else in the law. It needs to specifically say you don't have to do this in open meeting. Notice of your intention should normally be clearly noted in the agenda, written notice, so people aren't shocked that you're going to go into executive session. Public body is required by law to vote before you go into executive session by a 2/3 vote of members present, and the vote and the reasons for entering into the executive session shall be entered into the minutes. This is one of those few rare scenarios where you need to make sure not only who and how they voted, but why you voted to go into executive session or in your minutes, so that there's a question of, could you properly go into executive session? It's clear you have that. And in some cases that may be filled in by your legal counsel attending, giving you a script to say what you need to say why you're going into executive session. No votes or final determinations can be made by a public body in the executive session unless you have exceptions, like say hospital service districts for those strategy sessions. They have a very limited exception for those type of scenarios where they can vote in an executive session. But generally speaking, the executive session is for deliberations, for you to talk about things you necessarily can't talk about in public. And we'll talk about some of those examples, but the idea is you talk about them, but you come back out of executive session and actually cast your votes. So the public has a right to know how you vote, but there may be sensitive reasons why you can't see why you decided to vote. Examples of executive sessions that are authorized: discussion of character, professional competence, or physical or mental health of a person. The idea is because of privacy concerns, we don't want to necessarily talk about that person or the personnel, like the performance review of the person, where the board needs to meet and talk about things that may be sensitive. You have the ability to do it. However, it can't be used if it's for the purpose of appointing someone to a public body, because if you're going to appoint someone to a public body, the legislature has made a decision that people should be able to know why you're going to appoint or not appoint someone to that, or why you're going to award a public contract. The key here, though, is the person who is going to be talked about is the one who gets to make the call. You have to give them that notice 24 hours before the meeting. And if they want it to be an open meeting, it has to be an open meeting. And so we get the question sometimes of, do we have to let that person be in there when we go into executive session? Strictly speaking, the AG has said, you as a body make a determination who is needed to be in the executive session for the purposes of the executive session. Practically, what I will tell you is, if you tell someone we're not going to let you be in there and they want to know it, they're going to tell you they want an open meeting, and that their decision will carry it out. And so we have another code for you. This is verification code number 29. It is 7527. And again, this is verification code 297527. The other type of executive session that's allowed is for strategy sessions and negotiations on collective bargaining and litigation, whether it's after it's been filed or there's been a letter of written demand. The idea being, the public body needs to be able to discuss those things without the other side being able to say, hey, it's an open meeting, I get to hear everything you're talking about. The idea is, if it's going to be detrimental for your discussion on whether you want to settle or how you're going to fight this lawsuit, obviously those are things that the body needs to be involved in as a quorum, but may not need to be discussed in an open meeting. Discussions over actions for security plans and devices. And this was amended this past session to also include discussions of cybersecurity plans, financial security procedures, and assessment implementation of those procedures. And if you think about it, it makes sense. How secure is a security plan if you're broadcasting it for everyone out there? And so the idea is that for that purpose, to discuss those, you can meet in the executive session so that only the people who need to know the security details will know the security details. Investigative proceedings regarding allegations of misconduct. This is basically the other side of the personnel thing, where it's not necessarily the annual evaluation of the person. This may be a specific thing where you're looking at allegations. And so there's, because of privacy concerns and the fact that that person maybe that's being looked at isn't necessarily guilty until you can confirm it, you want to be able to have those discussions in executive session. And then cases of extraordinary emergency for natural disasters, epidemics, civil disturbances, repelling invasions. I don't know that I've ever seen that, or suppression of insurrections, but the idea is that in those cases, you may be able to meet in executive session. Certain meetings in the State Mineral and Energy Board, and then discussions of city and parish school boards and individual students and their parents. This is essentially the school board's equivalent of that first one we talked about, character and fitness. Well, this is when you have, because of privacy concerns of students, they have the ability for the parent gets the decision if they want it to be in public or not, but it can be, if they want privacy and you want privacy, to have that discussion on the agenda in executive session to discuss the suspension or issues of a student that involves a student. Obviously, because we want to give privacy concerns to students, this is an exception that's put in there. And then, of course, presentation and discussions of civil service boards on test questions. Kind of hard to give a test on people when you're discussing what those upcoming tests are going to be. Everybody gets to sit in the room and see them ahead of time. And so the idea is that if you're going over the civil test questions and approving the things that are going to be presented, you have the ability to have that in executive session. And then the second injury board, because of injury issues and personal medical stuff, they have ability to have some workers' compensation claims in executive session. And then, of course, any other matters provided by the legislature. And as we talked about earlier, hospital service districts, they can enter into executive sessions on discussions on marketing and strategy planning under the Enhanced Ability to Compete Act. It basically gives them a specific thing because the legislature wants them to be able to compete with private hospitals. And so before we move to the next thing on this, we're going to go ahead and take up a couple of questions that have come up just so we can kind of pare them down a little bit. We had a question that if the board does not appoint a committee, is it subject to the open meetings law? It depends. If it's an informal committee that essentially advises or takes action of that public body, they very well could be considered. The AG, and we'll talk about an opinion in a little bit when we go over the opinions, talked about that it doesn't necessarily have to be a formal committee to be it, like these private advising committees. But the key thing is, what are they doing? Is that entity essentially going to advise the public body, or are they going to take action on behalf of the public body? Those are more the questions. It's not so much that they are formally appointed. It can be an informal committee or subcommittee and still be considered a public body. We had a question, is it considered a walking quorum if the mayor calls, speaks to each member of the board concerning purchases that do not need to be bid? The key thing is going to be if it's an action that the board has to take action on, because the board is the public body. If it's that, obviously the mayor can talk with council members, get buy-in on things, because the mayor is not part of the public body. They attend and sometimes may head a meeting, but they aren't a voting member for most cases. Like for ordinances, they can't vote for an ordinance. The key thing is you don't want to constructively have a conversation between the mayor and all of the board on things that would need to normally come up and be discussed at the meeting to take action on or be advised on, because the public should hear that deliberation and not be kept out of it. That's going to be really what you look at, and what the AG has said about the walking quorum. Now, someone said they had a meeting in June and July. The president signed the minutes, but the secretary couldn't because of health reason. Can they type her name and upload to the department administration, or wait until they sign? I think that's one you may want to talk with your legal counsel just to see how your entity is set up. If the meetings have been approved, you may just want to coordinate how internally, if you have someone who handles those things, and take care of it, talking with your legal counsel. Do you also need individual notes listed in minutes for a committee meeting? If it's an action item where you're taking action on it, you generally want it because you want to make sure that you had the necessary votes to adopt it, if it's an action that's being taken. So committee meetings should be really no different than the big meeting, in the sense that you take minutes, you have a notice, you have agenda, all the same things happen for that as it would happen for the body itself. In the minutes, do you have to say how each member voted or just that it passed? In most cases, you want to, if it's an adoption of something, you want to know how people voted and what the yays and nays were, to show that a sufficient vote was there. Say for an ordinance, you really do want to know who voted yes, who voted no, and if anyone abstained, just so that there's no question that a majority of the entire body passed that ordinance. If the government authority is voting not to take an action, such as the table, is a public hearing required? The key thing is, if it's an agenda item where they're going to talk about it, you would want to have it in a public meeting, and then you could decide we're not going to take that up. Now, if they want to, if that's the only agenda item, you wouldn't just vote not to take it up. You would just cancel the meeting, because then there's no need for the meeting if that's the only agenda item and you're not going to act on it. You're not going to actually take it up. So if you post at the beginning of the year, do you still need to post within 24 hours? That's a good question. Yes, those are two separate requirements. If you have regular meetings that routinely occur during the year, that's one posting at the beginning of the year of when those meetings are going to be. You have a separate requirement within 24 hours to post for individual meetings, because those dates and times could change, or it's a reminder that this is going to occur on this date. Those are two different requirements. Your listing of all your regular meetings at the beginning of the year, and then the actual notices and agenda items for the individual meetings. If you think about that, it makes sense, because at the beginning of the year, you're not going to know what the agenda is for the individual meetings. You're just going to know when they are. Written notice of scheduled meetings has to be done at the beginning of the year. Again, just to kind of reiterate, if you by law, ordinance, or rules have adopted, or in your charter have provisions that you have to meet regularly, say once a month, you at the beginning of the year, you need to lay out when those meetings are going to occur, the date and times and locations, and send out a notice to the public that here's when those meetings are going to occur. Separately, when it comes time for the actual meeting, you're going to give within 24 hours, not counting weekends and holidays, and a notice with the agenda of that meeting so that the public knows what's going to be discussed and when, where, and what time that meeting is going to be. If we post a notice and add in the journal for the public hearing, but no one from the public showed and no one from the council showed up either, would it be a valid? Probably not, because to call it, you need to call it to order. And so you need, in order to call it to order, you usually need a quorum for the advisement purposes just as much. So if the meeting's never actually called to order, then I don't know that you could count it, but you need to look at your specifics and talk with your legal counsel. Can you email the notice to the media? Yes, the notice, in fact, that's generally how most of them in today's day would want it. So if you have media who have requested notices, just put in an email list all those people who have requested, so that every time you post it somewhere outside, someone sends that electronically through an email to all those people who have requested it. On agendas, if you have your title, say a resolution, but you change the body of the resolution, do you have to revise the agenda and repost? No. The agenda should just be the general agenda items, not specifically the item. Now, you may need to look at your rules. If it's an ordinance, the amendments of it may cause problems for your notice publications, postings, but that's something you have to talk with your legal counsel on. How would an auditor know if the agenda notice of meeting was posted on the website timely if the posting date is not documented anywhere? Obviously, you would look maybe routinely to see how things are, but generally speaking, if it's on there, the law does say if for some technical reason there was a reason why it wasn't able to be put, but they ultimately got it on there, it's kind of a no harm, no foul thing. They got it out there. The law says you need to do it by this time, but it also takes into account that if there's glitches, technical glitches or things, there may be a reason why it just didn't get posted timely. You mentioned the sheriff is not a governing body, but the law enforcement district is. If you have that, whoever posted this, if you have questions, please reach out to us. We'll talk to you individually about it, because there's some nuances that we'd have to go through, and I don't want to necessarily spend too much time right now. Do you publish minutes before they are adopted? Yes, because if you're not going to meet again, if you're a city, parish, government, or school board, the law says you have to provide those to your journal within 20 days of the meeting. And so if your meeting's not till next month, you have to provide those. Obviously, they're not formally adopted, but they should be close enough. Again, the AG says the idea is if there is something that needs to be changed and is changed at the next meeting, that will be in the minutes of that next meeting. And so we'll pick up some more questions in a minute, but let's kind of get back to where we were. The big exception, the virtual meeting exception that was created in 2020, there are some specific requirements that are needed for you to be able to do this. And so a public body can conduct and its members may attend and participate in a meeting via electronic means, telephone or video conference, provided all of the following. So if you only meet part, you can't use this exception. The first and foremost is the governor has to have declared a state of emergency or disaster involving your geographic area within your jurisdiction, and that the nature of that emergency or disaster would cause a meeting of the public conducted pursuant to the normal open meetings laws to be detrimental to health, safety, and welfare of the public. Obviously, this was written in the idea of COVID, but this could also be a situation where you have a hurricane, a flood, or things where the nature of that disaster would cause meeting at your normal locations or a location in that area to not be to be detrimental to health, safety, or welfare. Also, the presiding officer of the public body has to certify on the notice of the meeting that the agenda is limited to one or more of the following items. It needs to be agenda items that are matters that are directly related to the response to the disaster emergency, which are critical to health, safety, and welfare, obviously emergency procurement, things of those sorts. A matter that if they're delayed will cause curtailment of vital public services or severe economic dislocation and hardship. If you need to take a vote to implement something for the federal assistance, obviously that would be something you can't wait and need to do. The third one is if it's a matter that's critical continuation of the business of the body and is not able to be postponed because of a legal requirement or other deadline that cannot or has not been postponed or delayed. And the idea would be if you have a federal deadline for something that you have to finish and it needs a vote of the body to be able to certify and do it, that's something you can't wait for because the feds have required you to do it by this time. So you need to be able to take it up. And then finally, this was added in the second executive session of 2020. Any other matters that are critical or time sensitive that aren't necessarily one of the top three, but are things that the presiding officer feels can't be delayed. You can do those, but there's an additional requirement that once you get into the meeting, you cannot take those items up unless 2/3 of the members of the body present, vote to take those up. The idea is being they all agree, hey, we need to do this and take care of this. It's okay to do those, but you do need to make sure you follow all the certification requirements. Okay, and we have another verification code. Verification code number 30, it's going to be 6819, and that's verification code 306819. No later than 24 hours to the meeting where you're having the meeting under this exception, you have to provide all of the following. A notice and agenda for the meeting have to be posted on the website of the public body, emailed to any members of the public or news media who request notice, and you must widely distribute it to every known news media outlet that broadcasts or publishes news within your geographic area of the jurisdiction of the body. We've had this question before. What happens if you're a state board where you have statewide jurisdiction? Well, you probably want to make sure you have a list of all the major news, radio, and newspapers and stations so that you can send out a notice to all of them and say, hey, by the way, we're having this virtual meeting. In that notice, you also have to provide detailed information on how members of the public can participate in the meeting and submit comments. For example, if you're doing it through Zoom, like we're doing today, it would be where the link and how they can join the meeting. And then information that if they want to submit questions during it through the Q&A function, or if you're asking them to be emailed. The key thing though is they need to be able to also ask questions during the meeting. So you want to make sure that the public has ability to publicly comment both prior to and during the meeting. You also want to make sure that the public body is properly identified, that if you're using Zoom, for instance, where you see you see currently my name under my picture, just as in a meeting where you may have the person's name tag under the person, you want to make sure people can see who is speaking and who's voting when they come up on the screen. You also want to make sure you acknowledge public comments during the meeting and maintain those comments in your records. The presiding officer specifically has to ensure that each person participating is properly identified, and the presiding officer shall ensure that all parts of the meeting, excluding matters in the executive session, are clear and audible to all participants in the meeting, including the public. You want to make sure someone's kind of monitoring, like we have Lizzie for us today, kind of making sure that we're not just talking to the ether, that you can actually hear us and can get comments if there's a problem. Then finally, the telephone or video conference meeting under the exception has to be conducted where, the certification, got lost for a second. The certification, this is a sample certification. You can actually find this in our open meetings FAQ on our website under our legal assistance page. Under question 26 of the open meetings FAQ, we actually have a copy of the certification. You can obviously tweak it as you need to, because we have places like for date, time, or purposes. But this is essentially something we modeled off a thing the AG had given guidance on to be able to say, here's how you can give that certification that's required. Before we get into special provisions, one thing that kind of comes up a lot with the virtual meetings, we've got this question of hybrid meetings. And I think it's important to understand, yes, you can have some public, some present, and some virtual, but here's the catch. You can't have a quorum present physically, because if you have a quorum present physically, then arguably you fail that first prong of the requirement that having a meeting under the normal rules would cause a problem for health, safety, and welfare. If they're all present, you can, and again, let me clarify that because I think that could be confusing. If you have a quorum physically present, only the people physically present would then be your quorum, and they're the only people who can vote. You could still have your meeting on Zoom so that the public could participate and view it remotely. But you can't have a quorum of people physically present on the board and then have someone else join the meeting as a board member virtually. It either needs to be not a quorum physically present and everybody virtual, or you can have a couple of people that's less than a quorum in one location and then have everybody else remote. The key is, if you have a quorum physically present in one location, you basically are able to follow the normal open meetings law because you have a physical quorum present. The public can still observe, but they would do it electronically. What we've recommended in those cases is, if you have a physical presence and you have someone who would like to attend that's a board member, they can still attend electronically just like any other member of the public. They just can't count towards quorum, and they can't vote. They can comment just like anybody else would, observe it just like anyone else would. And I think what we'll see is, because people have found it to be pretty easy to do things through Zoom, it's a pretty easy way to kind of record and broadcast your meetings to the public while still being physically present in a location. The key, though, is that special provision is meant for when you can't get a quorum present because of the disaster, whether it's COVID or otherwise, so that in that rare circumstance, someone can participate electronically without being physically present, because there's not a quorum physically present in one location. So special provisions for taxes. If you are an entity that has taxing authority, you're probably familiar with this, but in case you're not, there is a special additional notice requirement. You still have your 24-hour notice requirements, but this is an additional notice requirement when a public body seeks to levy a new ad valorem property tax or sales and use tax, or increase or renew an existing tax, or authorize the calling of a tax. This is not to continue to levy the same each annual levy. This is only when you want to levy something new, increase it, or call for an election to submit it to be put to the public. In those cases, written public notice has to be published in your official journal no more than 60 days nor less than 30 days before that meeting. And you have to announce it during the course of a public meeting. That notice, just like your normal notice, has to provide the date, time, and location. And if you cancel or postpone that meeting, an additional notice of the new meeting has to be published at least 10 days prior to the new meeting. Now, this is important because if for some reason you have the meeting and don't take up the item, or if you decided not to do it, that's different. You have to start all over again with your notice in those cases. It's only if you cancel the meeting, you get a 10-day for the updated meeting. Now, additional notice has to be provided through hand delivery email to voting members of governing authorities. So if they're required to approve it. So if you're a board or special district who has to get your taxing measures approved by your parish council or your police jury, they need to be given notice of that meeting through email or hand delivery, as well as to the state senators and representatives in whose district all or a portion of that political subdivision is located. The idea being, if you're going to be calling for taxes or renewals or increases, they're going to get questions they want to know so that they're aware of it. No additional notice is required for meetings subsequent to adoption of the tax, in which the only action is to reduce it. So if you're basically just going to reduce the amount you're doing, you just need to give your normal 24-hour notice. And this special thing does not apply for roll forward actions, because those have their own notice provisions under 47-1705. If you are an entity has taxing issues and things of that sort, you may want to check the link below for lla.la.gov assessors millages. We have a lot of FAQs, and Joanne has a lot of information and contact stuff for those who need to deal with millages. Violations, if an action is violation of it, it can be voidable if legal action is commenced within 60 days of the action, and civil penalties up to $100 per violation can be assessed as a personal liability of the violator. The key thing in that first part on actions, let's say you adopt an ordinance. The law says that ordinance is presumed to be proper. Now, if someone takes an action, in this case, because they say you didn't do public commenting, within 60 days and challenges it, the court could void the action and require you to go back. The example we usually see where someone sees a deficiency and the AG has recommended this in cases, call another meeting, at that meeting, bring the agenda item back up, do it right, and it cures the defect. But the idea here is the 60 days is so if there's a technical deficiency, we're not going to hold you up after 60 days. 60 days, it's kind of like what the priest says in a marriage, speak now or forever hold your peace. Some AG opinions, to kind of go through those a little quick for you. 19-0128, that's an important one because he talks about walking quorums and emails and kind of a modern day version of the walking quorum and what to avoid. So if you ever have questions on walking quorums, this is an opinion you really should kind of look at and how he talks about it. Now, 19-0145, this talks about there's a special exception for these private citizen groups that are advisory. The law basically says those groups do not have to do notices and minutes because it's a group of private citizens. However, the public body who basically provides for this private advisory group to advise them, they are responsible for notifying the public of when that meeting is going to occur so that people can observe. It still has to be an open meeting. It has to follow all the other rules, but the committee itself of the private citizens is not required to take minutes and do their own agenda and notices. But that notice of the meeting, the public body who authorizes it has to do it. And again, this has to be uncompensated citizens. So if it's basically a group who's going to come up with nominations for awards or things of that sort, that would be the scenario. And in this case, it was a citizen group to come up with nominations for an annual ethics award. 19 and we have another verification code number 318247, and that's verification code number 318247. The open meetings law mandates everything be via voce, and that recorded minutes, this is basically a good one for that. It's the idea of showing hands alone is not enough. You need to have something that identifies who voted and how they voted. 17-0026, you can't circumvent the open meeting law by deliberating informally. The idea is things that public should be involved in and be able to see need to be done so that the public can see those things. Committees of political subdivisions, though, even if they're advisory in nature, are subject to the open meetings law. This is important for that point. Whether they're formal or informal, if they are a committee subcommittee, they're going to be considered the same thing, even if they're just advisory. As the publication and notice requirements were met, in this case, this is one where they cured it because they basically had an issue with public commenting. They came back at the next meeting, redid the vote. After letting public comment happen, the AG said that's good enough. You cured the open meetings defect. And then the last couple of these are ones that talk about whether nominating committees, and then ordinances about the idea about being placed on the vote unanimous. And then this is one 15-0122 about those procedures of adding things. You can provide procedures of how you're going to add things before the meeting, like you need to give us notice by this date and time to have it included on the agenda. But in no case can it lessen the requirements of unanimous approval to add something once you're in the meeting. And so we'll kind of skip from these other ones. And so we're going to go through this thing to kind of finish up because we had a bunch of questions. Before we get into records, don't your minutes have to be approved by the board before posting? No. If you're a municipality, a parish government, or a school board, the law 43143 specifically requires you give those to your official journal within 20 days of the meeting. So if you don't meet again until the next month, you obviously can't wait for that approval. What the AG has said is for the purpose of providing copies to people, you can't wait for that that can't be used as a reason not to give someone the minutes. Any changes that need to be done during that approval process will be reflected in your next meeting's minutes. Planning and zoning commissions need to publish minutes in the official journal. In some cases, those commissions, if they report to the public entity as part of like a reporting process, those may be included in those minutes, depending on how they do it. Is there any law or opinion on meetings being called at times difficult for the public to attend? Not specifically, but again, if that's more of a political question for yourselves when you want to meet. There's nothing that says you can't meet on a holiday night, but the key is you want to make sure, obviously, people can attend if they can. Anytime an item is voted on in public meeting, you have to list each member of the board and how they voted. Is this for specific items voted on or just vote in general? It depends. If it's just a procedural motion, sometimes that may just be with no objections. But if it's a specific item, like a vote to do something, or like a resolution or an ordinance, you want to make sure you know who voted and how they voted, because those usually require a specific vote. Like for an ordinance, it's a majority of those people on the board, not just who's present, but a majority. And so you need to make sure you have the votes for that, and that those people voted and how they voted. And in some cases for those, you may need it for your procedural reasons, because for reconsideration, depending on what rules you're using, that may require only certain people can ask for reconsideration if they were on the winning side, so that someone just doesn't keep bringing it back up and up. As far as police jury meetings have to be recorded, or you're saying that's not necessary? They may be recorded, but police jury meetings are not by open meetings law required to. Your own individual rules, your charter, or your ordinances may have made that a requirement, but generally speaking, it's a may for elected boards. You have to allow people to do it. Now, obviously, would you want to record it? Probably, because that helps the person doing the minutes later. But it's not necessarily a specific recording, but you have to allow people to record it if they want. As far as documenting recorder malfunctions, and what should be done if that happens, let's talk about that offline if you have that question. But you may want to talk with your legal counsel on that. The key thing is, unless you're mandated by law as a non-elected board or commission that has taxing authority, it's a permissive recording, not a required. Can you provide the agent opinion for providing minutes to the public before they're approved? If you reach out to us, the person who asked us, if you'll reach out to me after this, I'll be happy to get it for you. And do you have to give the public a copy of the financial reports? If they're a public record, which we'll talk about shortly, you need to give them, treat it as a public records request. And for ITEP implications for LD, you and either bring it. There are specific rules for ITEP. I would say talk with your legal counsel, because there's a lot of things and procedures that have been brought up, and that's kind of a moving target right now. Can a hospital service district continuously list executive session procedure planning on the agenda to discuss items such as contract? Depends. Obviously, it needs to be something that fits within the legal requirements. They can't just do it for everything. It has to be, again, for that specific purpose. And what is the proper way to remove agenda item? In some ways, it can just be someone makes a motion to move to the next item, or it depends on your rules. But generally speaking, someone could just say, I move, we take up the next item on the agenda. And so you just pass it over. As long as there's no objection in that case, that would be suffice, because that would show a majority we're okay with doing that. Obviously, if you've adopted specific rules like Robert's rules or something like that, you may need to consult those. Talk with your legal counsel if there's a question. Can all council members and mayors receive the agenda in the same email, or should they be emailed separately? They can all get that in the same email. It could be the same one you send out to the public. The key thing is you just want to make sure they don't communicate constructively as a quorum on the agenda. Does a hospital service district board have to adopt pay scale rates and open meetings? Talk with your legal counsel. Some of that may be permissible under Enhanced Ability to Compete Act provisions, but I can't tell you for certain. You'd have to talk with your legal counsel on that one. Does the 60-day notice apply to a utility company that plans to raise rates? That depends. If this is for millages, for sales and use and ad valorem taxes. If it's rates, that's different. That's something they probably need. If it's not a municipal company, utility, then they probably need to talk with the PSC. They have specific rules that you would need to look into. And what is a reasonable time for publication of the minutes and the journal? If you're a city, parish, or school board, you have 20 days. That's the law. Reasonable time beyond that may depend, but if you do it within 20 days, that's going to clearly be reasonable. Notification, notice in the journal, or 24-hour posting in the buildings. Is a Facebook considered notification of the council members? You need to look at your rules if it provides certain requirements for notice to council members, but in general, posting it outside is going to satisfy the open meetings law. but the other option is it's got to be in your official journal. Facebook would not count as that. That could be something where if you don't have a website where you're doing that as an extra thing to make sure people know, but the key is it needs to be in your journal or on the building for the open meetings law. Should minutes reflect public discussion on every item? If you're a school district, you may just have that public comment happened. You may have that no one spoke. You may have general that public comment occurred, just so that someone knows that it actually occurred before you voted. But again, it does not have to be verbatim. Is the public entity required to let public comment even if they did not send in to speak? Yes, it's a constitutional right. You may have procedures for them to do it, but you should not use technicalities to keep someone from commenting. That's why, generally speaking, you may, if you watch like the legislature, for instance, if someone wants to speak, they'll tell them, I don't have a card, can you fill one out? So they'll still let them comment, but they'll make sure they fill it out. The key thing is you may need that so that you have it for your minutes, but it can't be conditioned on that they have a right to participate as a member of the public. Housing authority meetings of subdivisions, that's going to be very specific to your entity and how it's created, but that's going to be if it's a public entity. And then we have another verification code, number 32, verification code 326157, and that's verification code 326157. And our roll calls votes necessary on resolutions. That depends on your procedures, but in general cases, it's probably just going to be a vote, yes and no. But although in resolutions, depending on what they are, a lot of cases, resolutions will put who voted and how, the number of votes yes, the number of votes no, just so it's clear that a majority voted for it. Those present voted for it. Okay, so we're going to go through the public records law. We won't spend as much time on this because I think open meetings law, I want to spend most of the time with it because I think it affects more of the people that would be of you guys than public records. The big thing to understand with public records, it basically says, just like the open meetings law, it's going to be construed liberally. So if there's a question of whether the public has a right to review or see that document, the courts are going to err on the side of giving the public access. We're going to talk about what is a public record, public body, and custodian. Public record, the legal definition gives you a really long definition of all these type of items that essentially are used for your business that you carry out. The key thing to know about that is that list of items is illustrative, it's not exclusive. So as technology changes, those things are going to change. What you really want to take from this is a public record is basically anything that's created, prepared, possessed, or retained as a result of the duties, functions carried out of the Constitution, statutes, ordinance, regulations, mandates, or orders. Basically, if it's things you get, create, possess, or keep because of the functions of your office, they're a public record. Or, and this is the one that gets all of us auditors on tuned in, anything related to the receipt or payment of money received or paid under the authority of the constitutional laws of the state. So basically public funds, we're going to track those. Public bodies are going to be any branch, department, office, agency, board, commission, district, governing authority, political subdivision, or committee, subcommittee, advisory board, or task force thereof. Basically, if it's a public entity, it's going to be probably be a public body. Here's where we get some catches. Any other instrumentality of the state, parish, or municipal government, including a public or quasi-public nonprofit corporation designated as an entity to perform a governmental proprietary function. So if it's a nonprofit that's created to do this or that you've contracted to do these things on your behalf, they may be a public body for the purpose of the public records law, especially if they're receiving public funds. Example I would point to this is the LASPCA versus the Bulldog Society of New Orleans. We actually have a white paper on our website if you'd like some more information about this. If your agency contracts with nonprofits to carry out functions for you, you really want to look at this and make sure you probably have this in your contracts to address how public records are going to be handled. And then affiliates of a housing authority, although they're not subject to a lot of laws, they are subject to the public records law. Custodian, this is the person who's the head of the public body having custody or control of the public record, and or the person who is specifically authorized. In this cases, you may have someone, in our case, we have our general counsel who responds on behalf of the auditor. Duty of the custodian, they have a duty to maintain and preserve and respond to requests. It's highly recommended you work with your legal counsel to respond to public records requests. 4433.1 mandates that you maintain information on the internet of who is your custodian of records, who they need to have. This was the CB for Gostin Act that basically says it doesn't necessarily have to be on your website, it just needs to be out there. So even if you don't have a website, you have to make sure it's out there somewhere who people should contact for public records requests. Exceptions, unlike the open meetings law, which can have it elsewhere, the public records law requires that unless it's in the Constitution, it has to be in either Title 44, 4.1 exec to be included as an exception to the public records law. It's not enough that it's in another statute. If you look at 44:4.1, you'll actually see it looks like a list of a bunch of statutes. That's essentially where they've incorporated by reference an exception somewhere else in the law. But that's needed and required in order to do it. Constitutional exceptions, the biggest one is right to privacy. That's why we always say recommend have your legal counsel help you with your requests. Some notable exceptions: criminal litigation or criminal investigations that are pending, proprietary and trade secret information. I would tell you this gets abused a lot. Private companies want to say everything's proprietary or trade. Obviously work with your legal counsel on that. Public blueprints or floor plans of public schools. We don't want people to have access to that for obvious reasons. Hospital and health related HIPAA records, personnel records. Obviously what person get paid is a public record, but the AG and the courts have said for privacy reasons, like your performance evaluations can likely be withheld. Tax returns, because as all things, tax records are protected, and then student records, things like FERPA. Now, maintaining records, essentially the person who has custody or control has to preserve them by, if the law says how long you have to preserve it, you have to preserve it that long. If the law doesn't give you a specific period, then it's at least 3 years, or as required on your approved records retention schedule that's developed and approved by the Secretary of State. You will note that the agency as defined in that statute is both local and state public entities. So a parish government is required just as much as a state agency to develop a records retention schedule. In the absence of one, and the law doesn't tell you how long a record has to be kept, it's 3 years. But I would caution you, there are a lot of things like HR records that it's for reasons you need to keep it longer. So we have a white paper on records retention, but I would strongly suggest if you do not have a records retention schedule, work with your legal counsel to reach out to the Secretary of State's office, the Department of Archives, to get one made. Recordings of public meetings, if you're required to, of those non-elected boards, the law specifically puts here that you only have to keep that for 2 years. And then note, this was changed in Act 213 of this last session to reorganize it so that it's law, specific law first, 3 years if you don't have a specific law and you don't have a approved schedule. Responding, the key thing is if they're a person 18 or older, they have a right to inspect, copy, or reproduce any public record. It doesn't include individuals in custody unless it's related to their post-sentencing relief. It does not extend to the attorney for the incarcerated person, as the Supreme Court ruled. Any person can obtain a copy or reproduction of a record. The custodian has the burden of proving that the public record is not subject to inspection, copying, or reproduction. This is why you want to work with your legal counsel. You cannot inquire why someone is doing that. So if you have someone who answers your public records request, make sure they don't ask people why. You can verify that they're at least 18. You can identify who they are and require them to sign a register, especially if you're going to let them access and handle records. And the request may be in person or in writing, and you need not include specific name or the document. A reasonable description of what they're seeking is sufficient. Charges, they need to be reasonable. If you're a state agency, there is a uniform fee schedule you have to use. Local governments can utilize the schedule if they want, because obviously if it's reasonable for state, it's reasonable for you. Clerks of courts, you're going to have their own civil fee rules. The big thing, this AG opinion 15-0056, you can't consider your original cost incurred in creating the record or the value of the record in establishing a reasonable fee. Only you can consider what it cost you to make the copy. How long do you respond? If it's not your possession, you need to immediately let them know this. However, you have an obligation to segregate out non-public or confidential information. So essentially, if someone shows up in person and you have the record available, they need to be able to go see it. If it's someone that's requesting it and it's currently in use, then you need to certify that it's unavailable in writing and fix a date and time within 3 days of legal holidays for the receipt of the request for them to examine it. I think the key thing to understand is if you call and respond to people, I've noticed they tend to work with you in getting a response. They're happy just in the fact that you've acknowledged that they've requested it. You must certify in writing you don't have a record and cite why it's not currently in possession if you don't have it. The key thing I think you need to understand within all this, you have 3 days with exclusive of weekends, so basically 3 business days to notify them of your determination that you're not going to give it to them and why. The key thing the courts have said is it's important you respond. You may not get it right, but you need to respond. So if someone is denied or they have the ability to take you to court to try to force you to give it to them, they also have, after 5 business days, if you don't respond to them, they can take you to court. The key thing on damages, and this is where the civil penalty is why it has an asterisk, the courts have said, if you respond, even if you get it wrong, but you've responded, they don't tack on the civil penalties. The key thing is you as long as you respond, you're going to at least not have that. You may have actual damages, you may have attorney's fees, but you're not going to have that. That's why it's always important for public records to respond timely and with your legal counsel correctly. We don't really have time to go through these, but I wanted to kind of provide you guys in the material some recent changes in the law that dealt with public records and when they became effective, just to kind of give you attention, because some of these may not be in statutes yet because of the way that process goes. And so with that, thank you guys for attending today. If you have questions, please reach out to us. I will say, if you go to our legal assistance page, we have ability for you to submit a question. You see it in the bottom in red. And if you have questions after all this, please reach out. If you want to talk to Jennifer, I've provided you her contact information, my contact information. That number can also be used to reach out to Ms. Heath, who spoke yesterday. So with that, I thank you guys very much.
Great. Thanks so much, Patrick. We are going to take a break until 10:10. I just wanted to mention about the CPE verification codes. I've gotten a few messages. We are unable to repeat the codes. So if you miss one, please don't forget to submit your verification form worksheet. You can still receive credit, but like I said, we're unable to repeat those codes. So take a break and see you back at 10:10. Our next session is Local Government Budget Act with Jennifer Shea. See you soon.